Hello, my name is Jeremy Prain. I'm a partner in the Maritime and Transport Department of Bowman Gilfillan. I'm going to be talking to you today about the ability to arrest property in order to obtain security for a claim which has been commenced or is contemplated elsewhere. This is commonly known in South Africa as the security arrest. Although the procedure has been available for a number of years since the enactment of the Admiralty Jurisdiction Regulation Act in 1983 and has been used to good effect during this time, it's really come back into sharp focus since the recent judgments in the United States dealing with the Rule B procedure, in terms of which the US courts severely curtailed the ability of a maritime creditor to attach funds through the New York banking system. What has happened as a result is that many maritime creditors are looking elsewhere to obtain their security. And in this regard, South Africa has, as I mentioned earlier, come back into focus. The arrest regime in South Africa offers far-reaching possibilities for maritime creditors. In addition to the ability to arrest a ship associated to that, in respect of which the claim lies, it is also possible to obtain security purely for the purposes of obtaining security for proceedings that have been contemplated or have already commenced in a foreign jurisdiction. For example, one finds that it is possible to arrest property in South Africa in respect of a charter party or bill of lading dispute where the substantive claim is being decided or is being judged through London arbitration or the High Courts of London, for example. There are a number of requirements that are required to be shown in order to obtain a security arrest. The first is that it must be proved on a balance of probabilities that the claimant has a maritime claim which is recognized in South Africa in terms of our legislation. This requirement seldom creates difficulties for a claimant, since the Act has such a wide definition of the term maritime claim. One really needs to establish simply that the claim is of a marine or of a maritime nature. Secondly, the claimant must establish that it has a prima facie claim, which is prima facie enforceable in the nominated forum or area for dispute resolution. This requirement too seldom creates difficulties, since the threshold for prima facie is particularly low. The claimant need only show or adduce facts which, if proved to be correct at trial, would be sufficient to establish a cause of action. A third requirement is that the maritime creditor or claimant must show that it has a genuine and reasonable need for security. This must be proved on a balance of probabilities. This provision has been the subject of much judicial scrutiny over the years, and the latest judicial pronouncement from the Supreme Court of Appeal is that a claimant must show that it has a genuine apprehension that the debtor will not be able to satisfy the judgment or the award made in favor of the arresting party. This apprehension may be founded upon actual knowledge that is in the possession of the maritime creditor. Alternatively, and would be more often to be the case, built on an inference of facts that the debtor does not have sufficient assets, or that it might seek to conceal those assets, or in another way frustrate the payment of the award once made. As far as the procedure is concerned, the claimant must bring an application in the High Court of South Africa. This application is made ex parte, without notice to the owner of the property, and is founded upon an affidavit to which is exhibited evidence adducing the basic facts of the case which need to be established. It should also be noted that the posting of counter-security is not required in order to obtain an order for arrest. Also, it should be noted that the associated ship provisions can be used in conjunction with the security arrest procedure. Finally, if and when an order is granted arresting property, this property may be released upon the provision of security. In the normal course, one would expect to receive a P&I club letter of indemnity, or alternatively a bank guarantee. there are, of course, other ways in which one might be able to secure the claim. This is the basic outline of a security arrest in South Africa, and further advice should be obtained should one seek to bring an application of this nature.